Welcome to SpicyIP podcast Summer School Edition. Today with us we have two distinguished guests, Dr. Binay Panda and Mr. Prashant Reddy. Dr. Binay Panda is a distinguished academic at the School of Biotechnology, JNU New Delhi, and Mr. Prashant Reddy is an author and an academic who has experience in law firms in Delhi and has experience in academia in India and Singapore. Today we are going to be discussing the Delhi High Court judgment in the Regents of the University of California versus the Controller of Patents. In this case, the claim related to a recombinant salmonella microorganism based live vaccine for preventing enteric bacterial infection, which was refused by the Patent Office and an appeal was upheld by the Delhi High Court. The sections under which this was refused was under Section 3C and also Section 10 for not sufficient disclosure. So, sir, can you explain what the invention in this case was?
Thank you for having me. This invention is actually a national phase for the PCT application. The invention is about a vaccine for animals against a specific bacteria called Salmonella. Salmonella enterica is basically enteric bacteria, the multiple strains of this bacteria, and causes actually huge loss to the livestock. And the most important thing about this vaccination is also there are 4 or 5 different antibiotics which are known generic antibiotics. Many of those strains of Salmonella are resistant to that. And therefore it's very important to introduce vaccinations in animals because there are loss of just animal life, livestock, but also of course the revenues generated by the livestock. So therefore the invention which was originally filed as I mentioned as a PCT application describes a process where there are loss of function mutations, and when I'm talking about loss of function mutation, that also includes the constructs that deletes a portion of the gene in frame. And what in frame deletion means that you delete a part of the protein without disrupting the prior and after part of the proteins. So for example, if the protein is 100 amino acids long, you delete amino acid number 10 to 20. That means between 1 to 10 is same as before, between 20 to 100 is same as before. This particular invention talks about deletion in 2 genes. One is DAMP, which is a methyltransferase gene, and in another set of genes, there are 6 genes they're talking about, out of which 3 important genes. So there are 2 different genes in a set of 7 sets that the invention talks about, and testing these particular deleted mutant strain of Salmonella to develop a live attenuated vaccine, very similar to which many of you might be aware of what happened in the case of Covaxin, which is also a live attenuated vaccine. So how to create a vaccination strain with the live attenuated strain of Salmonella, which lacked 2 different genes.
Thank you, sir. When we look at the controller's order and when went to the appeal to the Delhi High Court, in the judgment they have focused on Section 3C, which says that living or non-living substances cannot be patented, which do not occur naturally. We have Section 3J, which says that plant and animals other than microorganisms. The background we all know that TRIPS agreement came and microorganisms were supposed to be patented, so there was a specific exclusion there. So can you talk about this interplay between Section 3C and 3J? And has there been a mistake when they have omitted a discussion on 3J?
So just to briefly recount the grounds on which, one of the grounds on which the patent was rejected by the Patent Office and upheld by the Delhi High Court. So the Patent Office had invoked Section 3C, which basically says that naturally found organisms cannot be patented. And the Delhi High Court had upheld that particular interpretation. Now, there are 2 problems with how both the Patent Office and the Delhi High Court approached this. Number 1 is the fact that apart from Section 3C, which clearly bars the patenting of naturally occurring organisms, there's also Section 3J, which creates an exception for microorganisms. So, and the history of this particular provision goes back to 2005, when the Patent Act was being amended to bring it in compliance with the TRIPS agreement. At that point of time, there was a lot of opposition from the left. By left, I mean the CPIM at that point. which was one of the members of the ruling coalition. They did not want microorganisms to be patentable subject matter. And at that time, the government, which was the minister of the day, was Kamal Nath. He was the commerce minister. So he basically said that, we need to include this because the TRIPS agreement requires us to protect, to allow for patents for microorganisms. In any event, I'll set up an expert committee to study this issue. Dr. Marshalkar headed that committee. The committee went into a lot of controversy, plagiarism, etc. But at the end of the day, they also concluded that India, if it wanted to be in compliance with TRIPS, had to recognize microorganisms as patentable subject. It's actually microorganisms and microbiological processes, which there's some confusion on that issue also. So basically, the law is very clear now that microorganisms have to be patentable. So the moment a patent claims a microorganism, a patent application claims a microorganism, that means it automatically has skipped the bar of Section 3 of the Patents Act. Because Section 3 basically lays down what are not inventions, right? So if you fall within one of the exceptions of Section 3, in which case, which is true for microorganisms, then the Patent Office doesn't have to do any kind of Section 3 analysis. You just jump to the novelty, obviousness, utility analysis. In this case, surprisingly, the controller seems to have missed the fact that this was a microorganism which has a clear carve-out. And also it appears that University of California didn't raise this argument because it wasn't dealt with by both the controller of patents or the Delhi High Court. So it's very likely that University of California did raise this argument, which is quite an oversight on its part. The second issue is when the controller raised the Section 3C argument, the University of California basically amended its claims to say recombinant DNA, which basically in the state of the art means that there has been some kind of human intervention to modify a gene. So the moment you use that word, you're basically saying that we have done this in a laboratory. It is not naturally occurring. And for reasons I can't understand, both the controller of patents and the Delhi High Court again appear to have missed the meaning of the specific word recombinant. So those were the two primary objections that I had to the court, how this issue was approached.
Thank you. So the way I read this is also very interesting. As Prashant said, that the amendment started in 2005 to include microorganisms. But as I see the Section 3, if somebody is objecting Section 3, the onus is on that person to prove that this occurs in nature. Now, there are cases of bacteria where the mutant strains are actually found in nature. But in this case, to the best of my knowledge, and I obviously haven't read the zillions of literature, but to the best of my knowledge, there have been no cases of Salmonella mutant in the said genes found in nature. Now, what I'm surprised in this controller's argument that this is naturally occurring. Now, as Prashant mentioned, that the word recombinant itself means that they are not naturally occurring. However, if the controller objected this under Section 3, I would have given the exact prior art where it has been described that these mutants are found in nature, and that was not the case. But having said that, as I mentioned, there are cases of naturally occurring mutant, but to the best of my knowledge, not in Salmonella.
Okay, so just one additional question on that. When we're talking about human intervention, we're just saying that if there is human intervention, we are not going to look into the standards of how much of an intervention there should be. If there is intervention, it takes you out of that 3-wala argument.
So, Section 3, as a scientist, if I read Section 3, as Prashant said, it says what cannot be patented, right? So, it's a subjective matter because how much of scientific intervention is needed to alter an organism to make it non-natural depends on the organism to organism, depends on what I'm trying to introduce. For example, if there are right now modern technology available, within a day I can change a new gene to make a mutant gene. So I think the quantity of intervention is not the issue here. The issue is that particular mutant gene within the same bacteria is found in nature. Now, one may be hypothetical here, which is completely hypothetical now. What if a mutant gene encoding bacteria is discovered tomorrow within the time frame of this 1 year time frame? Then in that case, probably the controller examiner is fully within his or her rights to decline the patent. But in this particular case, as I mentioned, neither to the best of my knowledge nor the controller in the argument provided prior art suggesting such.
All right. So, the second question is on the deposit requirement. There was this another issue in this case. Under section 10(4)(a) and B, there was a requirement of depositing the microorganism if it was not sufficiently disclosed to the best method and it was not naturally occurring. And the Delhi High Court said that this condition is not being fulfilled. So you are in contradiction. So what's your take on this issue, whether there was the deposit requirement met in this case or not?
So I think, Prashant, you should take that because during the discussion just before this podcast, we are talking about it and you were showing the section 10(4).
Yeah. So basically, I mean, the deposit requirement, it needs to be seen in context of the whole of section 10, right? So section 10 lays down the requirements for what we know as the enabling requirement under patent law. That is, if a patentee is getting a monopoly for 20 years, then the onus is on them to, in exchange for that monopoly, make a disclosure to society on how exactly their invention can be worked. That means that a person skilled in the art should be able to read the patent specification and reconstruct that invention in a manner so that it works as how it's described in the specification. Now, in the context specifically of biological substances, they do not always lend themselves to a written description just because of the nature of the organism, and they may not always be found everywhere, right? So, in order then to meet the disclosure requirement under patent law, where you want that knowledge exchange, where you want the patentee to exchange that knowledge with society, you have a deposit requirement. Now, that deposit requirement, however, under Indian patent law is subject to certain specific conditions. That is, if you do not meet certain specific conditions, then you have to mandatorily deposit that particular organism, microorganism, in a particular, under some treaty and some institutional depositories. So over here, one of the conditions is the microorganism publicly available? And does the state of the art, second condition basically, I'm summarizing them, is that does the state of the art enable the person to basically reconstruct the claimed mutation in this case? So over here, Salmonella is widely available. The mutation, from what I understand, how to conduct that mutation, etc., is also known generally in the state of the art. Now, if those two conditions are met, then you can't ask the patent applicant to deposit the microorganism as per section 10(4). The larger problem here is how the controller has approached this issue. Like Dr. Panda raised even in the previous point. The fact that when a controller said, right, that this is naturally occurring, she never produced a document to show the patentee that this is naturally occurring. So same case over here, when you're saying that an enablement requirement is not being met, then you also have to say, you have to give certain, an explanation as to who is a person skilled in the art, what would they have, like what is the deficiency in the patent application, which would have prevented them from, enabling this disclosure by themselves. So the controller just can't have their own personal opinion to reject.
So this is a question you were asking about the deposit. Yeah, the section 10 clearly says that you have to deposit if somebody who is skilled in the art cannot reproduce it from the existing knowledge and the sequence available. It's not the case here. However, I don't remember the original invention document by the UC mentioning exact location of deletions.
You supplement.
Yes, implemented. Now, what I mean by is that they are talking about the infinite mutation of DAM gene and infinite mutation of other 6 genes that I mentioned total. Now, is the controllers, and this is all our speculation right now, is the controller saying that the organism that the plaintiff is describing has to be identical? Now, if it is identical, then the plaintiffs must tell not just the mutation in the genes, but also tell exact location of the mutation. Now, again, it's been quite a while since I read the original invention document, but I don't remember telling or describing this particular locations. And what I mean to say is that think about if a gene is 2000 nucleotide longs, nucleotide means 80 GCR4 double bases. I'm telling that the mutation is at the location, or the deletion mutation is between location 10 to 45. That means I'm taking 15 nucleotides out. Okay, now my new gene has become 1985 instead of 2000. Now that 15 can be deleted anywhere, right? Unless I say the location of deletion is between location 5 to location 20. And and this is all speculation because we don't know what the controller meant when the controller said that it has to be deposited. If the controller means that the location has to be specified, then yes. But again, going back to 10, section 10, it doesn't really say that. It says that somebody who is skilled in the art can reproduce the organism with the mutation, and the answer is yes, without the exact location. Because again, the claims don't actually say, this particular mutant strain is giving the benefit to the vaccine. Because for a vaccine to be efficacious, there has to be something called therapeutic index. So that means, is the vaccine safe? Is the vaccine safe enough in the sense, because in animals what happens, or in humans, when we get vaccinated with live attenuated vaccines, there is shedding. That means the shedding has to be minimum. And the toxicity is obviously, if it is a non-live attenuated vaccine, toxicity has to be minimum. In case of a live attenuated vaccine, the infectivity of the live attenuated vaccine also has to be very minimum. That means if the animal is shedding the virus has to be non-infective enough that the shed virus cannot actually infect other animals, right? So in this particular case, that the plaintiff is arguing that the mutation in these 2 genes in multiple combinations is good enough to have all the characteristics which is required to give the the enablement to make the virus enable to have the immune response, at the same time making it really safe. That means the shading is good. They have given the data on that. So whether if you read clearly the section 10, I don't think she should have deposited the mutant strain in as per the Budapest agreement. But again, this is, as I said, hypothesis that if the controller means that the exact location, then the answer is yes. So we can only guess because we don't have much clarity on that issue.
Thank you. So last question is, where does biotech go from this case?
So, well, if it's basically this deposit requirement, if it's upheld, I'm sure, I think University of California will file another appeal. I'm not sure if they're going to be filed to. But basically, if this deposit requirement is upheld, that's going to be a major problem for the biotech industry. It's going to increase costs because they have physical costs associated with physical legal costs associated with depositing a microorganism, and presuming the microorganism is the dangerous kind, then there'll be additional safety requirements, etc. So it's going to increase the cost of patenting for the biotech industry. And also, it's now increased. The judgment has just caused a lot more confusion on how biotech patent applications are supposed to approach some of these issues. On some points, it's clearly wrong, right? It's how you apply in Section 3C, not looked at microorganisms in Section 3G. That kind of policy uncertainty is never good for the biotech industry. you are trying to attract investments, for research, etc. It's not a good. You don't want to have this kind of uncertainty. I mean, obviously, research will continue because a lot of innovations will still happen for the American market, the European market. But it's going to hurt, say, local innovators who are looking more at India as their target. So, from that perspective, I think the biotech industry may be a bit unsettled. The only good thing is there's no Indian consistency even within the Indian patent office and the Indian courts, right? So it's very possible that the other controllers just ignore this. The other judges in other high courts also ignore this. And then you have a situation where it is both allowed and not allowed. So it's in a state of death and
Conflicting and challenges.
yeah. So this khichdi keeps happening in Indian courts. But yeah, uncertainty is never a good thing.
I think the broad implications for science and innovation is, let's talk about the good, bad, and ugly. Good is we know that this has now come out, and we know what not to do from a point of view from inventors. And the bad is that also it sets a precedence, because almost all court litigations take the precedence into account. So there is a huge confusion among the Indian and non-Indian inventors going forward is, what is section 3C/3J? What do we consider, what is the definitional argument for natural occurring? To me, the controller's argument in all of the sections are actually not that important. The central argument is section 3, because the 10 is okay, is minor, as we talked about. Then there is also, the controller talked about section 59, post the appeal, because they were talking about the word recombinant is no longer acceptable when they filed later wanted to introduce that. But section 3 is very, very important, and it has implications. So do we consider a mutant strain, lab-induced mutant strain, to be natural? And if we have to go by the controller's judgment, yes, but I think that sets a very bad precedent. Because then we are basically saying that if you change any microorganisms, it's not patentable, or it depends on how the controller reads it. That is subjective. Then that's not 3J, that's a completely different things we're talking about. So that part is really confusing, and I'm sure that the lesson to be learned here is that we need more uniformity. I take a step back, and this is important to state. What happened in this particular case is not different than what happens in any case, in even non-patent or anything in our society. It's an evolving thing. We have less manpower, and we have less trained manpower. So things are just, getting things done as we go. So the positive thing we have to take it that confusion may happen, but I think court particularly, because here the interesting thing is the judgment from the High Court sets a precedence. That means tomorrow somebody says that how come you are not granting me a patent based on exactly the same argument, or rejecting a patent based on the same argument. So I hope that the judge takes this into account, that we need to clarify how section 3 should be read and how the message goes across to the inventors. And it doesn't matter Indian inventors or non-Indian inventors, because if we want non-natural thing to be invented or inventable, then we have to send a very clear message. And unfortunately, that clarity is missing in this particular controller's argument.
Thank you, Mr. Panda.
Thank you.
Mr. Reddy.
Thank you.
I think it was a very interesting discussion, even for our viewers. Thank you for taking the time out and having this session.